SCOTUS, they are very busy this time of year, handing down some very key decisions, landmark decisions. One of those that they handed down was allowing the count of mail-in ballots today. It was a 5-4 decision. That was a Mississippi law that was challenged by the RNC that does not unlawfully conflict with the federal law that sets election day in early November when you counted these mail-in ballots, because there's a lot of states out there that have ballots that come in after Election Day.
That is accurate. You were hitting it right on the nail. We're 4 months out from midterm elections in 2026, and this is a case that's going to have direct impact on the midterms and how states run and operate their election day counting, their after election day counting. If it's legal, is it something that can be done? Do states have an ability to do it? That's all the discussion that was in court when they talked about this. This ruling was Justice Barrett, joined by Roberts, Sotomayor, Kagan, and Ketanji Brown Jackson. And so you do have a split of ideologies.
Strange bedfellows here for sure when it comes to conservatives and liberal justices. Yeah.
We're not seeing that lately. Typically, is it right across ideological lines? We did not see that here, and for good reason. You look at a couple of things that Barrett said when looking at this. She struck down a number of the arguments that were made by RNC, talking about specifically, they said, well, the original founders didn't contemplate these types of things occurring, that election day was the only day. And because at the time we didn't have early voting and we didn't have these other mechanisms, we should apply a 19th century approach to this, is what their argument was. And she shut that down instantly, saying at the bottom, the challenger's theory assumes that because modern elections are governed by the 19th century statutes, they must also follow 19th century voting methods. Taking that logic's conclusion, she noted that argument could also cast doubt on early voting, since polling places in the 19th century were generally only open on election day. Historical practices alone, she wrote, cannot override the statutory text, meaning that you can have adjustments, amendments, and new inventions throughout time, but you still can have the statutory and historical context of what they were intending to do. And her rationale specifically was the election day statutes require that the electorate's choice, not ballot, the choice be made on election day. So she says, so as long as the election day deadline hasn't been moved, they're in compliant with the statute.
Now you're talking about the Justice Coney Barrett there.
Correct.
Authoring that ruling, but writing the dissent, which is always fun when you listen to Samuel Alito.
My favorite part.
This is great. He argued a decision that could threaten election integrity and fraud. And here's my favorite part of that. He said the majority based its decision on a flawed understanding of election day statutes.
Justice Alito is definitely, as he continues to sit on the bench, is not mincing his words with his disdain for the other side's approach to their reading of the Constitution. Last week during oral arguments, when Justice Sotomayor read her dissent, he rocked back and forth, shook his head in frustration, kind of mocking as she read. And then when she was done, said, well, if I knew you were going to read your entire dissent, I would have added more into my opinion to strengthen the argument. So there's this back and forth frustration by him that is showing more than it's ever done before. That historically wouldn't happen, where you have Supreme Court justices going at each other in the middle of the court. And so this frustration is now spilling out into his dissent, where he's saying, listen, you guys are not even reading the law accurately, or the Constitution is being misunderstood and misinterpreted. But this, as you mentioned, this Supreme Court law follows statute. What they're saying is, did they specifically say you can't do this? And the answer to what Barrett said is no. They didn't explicitly say that there could be no ballot counting after elections. And because they didn't specifically say it, now Congress either will authorize it or they won't. And because they haven't authorized it, or they haven't disallowed it, states will now have the ability to do it. So my looking at this case, I remember when it first occurred, when it first was granted cert, I said, well, this sounds like the mailbox rule, famous case from law school, where it talks about once something is placed in the mail, it's deemed to be a contract, that you don't have to receive it. I've placed it in the mail, now it's binding. It's the same situation as this. I've voted already today. you may not receive it for 7 days later. That doesn't mean my vote wasn't effective prior to Election Day. Now, the court didn't use the mailbox rule for this rationale, but it said, listen, they didn't specifically say you can't do it after. So because they didn't outline that you can't do it after, now allows us to say that, look, this is something that states can do. Not required, but can do.
Yeah, and obviously this is a big blow to President Trump, who's attacked mail-in balloting, claiming fraud, especially in states like California, where it takes a week to 2 weeks after to collect ballots. New York, Pennsylvania, that we saw in the 2024 election, Texas, several other states. But going forward here, there's no attacks on this for the midterms. Legally, are there any challenges that could possibly come up?
I mean, I see folks attempting to challenge other locations. Like even North Carolina could potentially be challenged. You got to think about it. North Carolina has extremely strict rules regarding this. That's why I brought up that point about how it doesn't require that you do that. So this Mississippi law was in place, and it allowed them this grace period to count the ballots, right? Someone challenged it and said this is unconstitutional. It shouldn't be allowed. Statutory guidelines don't allow for it. Wipe it out, pointing to the 1858 designation of federal statutes regarding a national election day, right? That's what they were arguing there. But North Carolina is saying they have to be received on election day by 7:30. That's what our law says. So the court went on to say, we're not telling Mississippi or North Carolina they can or they cannot. We're saying that, I should say, they're not saying that they're unconstitutional. What they are saying is you, states, can make the determination. So they're not saying that you have to have a grace period. They're leaving it up to the states, General Assemblies, to make the determination. So back to North Carolina, our General Assembly said we want to have no grace period. Court saying that's fine. Mississippi, we want to have a grace period. Guess what? That's fine. So to your point with President Trump, yeah, that's going to be a hard thing for him to get around. His response to that with the social media post was pass the SAVE Act. So now you can have something like this on a nationwide basis. I think the issue with that will be they point to this case. If you attempted to pass something like that in the SAVE Act, then it would kind of put us in litigation all over again.
Queen City News Plus. Just search Queen City News on your smart TV's app store.